Thank you for having me for this session to discuss the legal context of anti-2SLGBTQ plus online hate. My name is Rosel Kim, and I use she, her pronouns. We have about an hour together. I'm hoping my remarks will be about half an hour. I'm going to be providing a high-level overview of potentially applicable legal remedies for online hate in Canada. And I'm going to be doing that, providing, what the criminal law says and what the civil law says. And then I'll end the session by providing some sort of concrete steps that someone could take, or if you are experiencing online hate, or if someone you know is experiencing online hate. So I actually don't know how to move. I guess I can move myself like this. But so no presentation from a lawyer would be complete without a disclaimer. So I'll just quickly say that the content that's discussed during this webinar, it's supposed to be for general information only and doesn't constitute legal advice or opinion. And if you have any questions pertaining to a specific situation or you would like individual legal advice, please contact a lawyer or a legal clinic. Great. So to begin, I want to first kind of situate this conversation in my position. So I'm joining you today from what's known as Toronto, and that's the traditional lands of the Mississaugas of the Credit, the Wendat, as well as other Anishinaabe and the Haudenosaunee nations. And the land I'm joining you from is governed by the Dish with One Spoon Wampum Belt Covenant between the Haudenosaunee and the Anishinaabe, as well as other allied nations, and Treaty 13. Many of the treaties and agreements that we reference in the land acknowledgements were broken and violated by settlers, and we are still living with the ongoing colonial violence against Indigenous people, which disproportionately impacts Indigenous women, girls, and Two-Spirit people. So I mentioned this for a couple, and I want to sort of think about the role of the law as I talk about this, because one tool of colonialism has been the law, the legal system, and the actors within it. And as somebody who is an immigrant settler and a member of the legal profession, I want to kind of situate myself in that, and to remind ourselves that the root cause of online hate first is systemic oppression, like colonialism and systemic racism, as well as homophobia and transphobia, and that these, online hate is not divorced from real life, quote unquote, and also the impact of online hate are, not less severe or less serious because online life is real life, as we all, I think we know. And the other reason I wanted to mention is that, when we discuss legal remedies, I think it's important to understand understand the colonial roots of the law, and especially when we talk about the limits of the law and the need to maybe imagine solutions that exist outside of the legal system. So with all that said, I will move on to discussing hate in the criminal law. So what does the criminal code say about hate? There are a couple of sections in the criminal code that talk about hate. So this is one section on advocating genocide, so which makes it an offense for anyone to advocate or promote genocide. And genocide is defined as acts committed with intent to destroy, in whole or in part, any identifiable group. And in this case, the identifiable group includes grounds like race, age, sexual orientation, gender identity and expression, among others. So that's the section on advocating genocide. And here is another section, section 319, on inciting and promoting hatred. So Section 319 makes it an offense to incite hatred against any identifiable group where that incitement is likely to lead to a breach of peace. And then it's also a crime for anyone to willfully promote hatred against any identifiable group. So what does this exactly mean and how does it work? And you might already see that hate speech, as it's known in Canadian law, has a pretty specific and a bit of a narrow definition. And this means that a lot of hate that is harmful and has negative consequences is not necessarily illegal. The way that the legal system works in Canada is that there's a law that's written, like what's in the criminal code, and then the judges are asked to interpret that law so that they can sort of apply it to different situations and see whether that law applies to specific situations and and other things like that. So in Canada, the Supreme Court is the highest court in the country. So if you start a trial, you would go to trial, and then it might be appealed to the Court of Appeal in the province, and then it could go up to the Supreme Court. So that means that whatever the Supreme Court says has, it's kind of the final say on the interpretation of that law until the Supreme Court might be asked to revisit the issue. So I want to share some of the things about what the Supreme Court has said about the criminal code sections on advocating genocide and also inciting and promoting hatred. So what the Supreme Court has said is that hatred connotes an emotion of an intense and extreme nature that is clearly associated with vilification and detestation. And the court also clarified that you don't need to require proof that the communication caused actual hatred or violence, and acknowledge that it would be difficult to establish that kind of causal link. And in terms of what it means to willfully promote hatred, the court said that the accused has to have a conscious purpose to promote hatred against an identifiable group, or they sort of foresaw that the promotion of hatred was certain to result as a result of their communication, but went ahead with it anyway. So in Canada, in order to qualify something as a crime, you need the mental element. So you need to kind of prove that somebody had the mental element as well as the act that was harmful, and that they had to exist together for the crime to qualify. And that's sort of what the Supreme Court has said about what hatred or what hate crimes mean. And you might be wondering why the definition of hate is defined like this, or why it's a bit narrow. And the answer to that is the Charter of Rights and Freedoms. And that's a part of our Constitution, which outlines the fundamental rights and freedoms that we have as people living in Canada. And freedom of expression is one of these guaranteed fundamental rights in the Charter. Now, something that's unique to our Charter rights is that none of them are absolute. So things like freedom of equality, freedom of expression, they are very robust, but they are subject to a limitation that's in Section 1 of the Charter for a democratic society. There are a couple of reasons why a right might be limited, and there's a balancing that happens. So in this case, freedom of equality and freedom of expression may be sort of competing, and the court is asked to balance that. But at the same time, freedom of expression is a pretty broadly protected freedom. And that is why the scope of what actually counts as illegal criminal hate speech is so narrow. And you need to meet a very specific threshold of, high intent and high emotion for something to qualify as hate speech. There was also a constitutional challenge to Section 319 of promoting hatred when a high school teacher in Alberta challenged that the criminal hate speech provision infringed on the freedom of expression, but the Supreme Court found that it was constitutional on the balancing of these rights. So that's an overview of what we mean by hate speech or hate crimes generally in Canada. And the other thing I wanted to mention, before I move on to this, is that if you want to prosecute any of these hate crime offenses, there's an extra step that you need to fulfill. So for inciting or promoting hatred, or for advocating genocide, if you want that to go forward, you need the permission of the Attorney General's office in the province for that to be prosecuted. And this is only unique to those two sections of the criminal code, meaning usually when a crime is being prosecuted, it's the prosecutor who's on the file with the police who decide to go forward with a criminal trial. But for these two hate crime provisions, you need an extra permission from the Attorney General's office itself. And that sort of creates another barrier or limitation to pursuing these kinds of hate crime charges. That being said, there are other types of offenses that acts of online hate might fall under. So I won't go into these in detail, but I've just listed some of them here. So they include things like publication of an intimate image without someone's consent, criminal harassment, uttering threats, there's extortion, identity fraud, and intimidation. I'll just talk briefly about this thing called the peace bond, which is at the end of the right-hand column. So that's when you could ask for a court order. Anyone could ask for a court order if they're afraid that another person might harm them, their children, or their property. And this is under Section 810 of the Criminal Code. And then you can apply for a peace bond where basically the other person is promising to keep the peace. And what keeping the peace might mean could have different conditions attached. So to keep away from somebody, to not do something, you could attach different conditions to the peace bond. And this would last, I believe, for a year. Some of you may remember that John Gomeshi actually signed a peace bond in 2016. One of the complainants that came forward withdrew the charge of sexual assault, and he agreed to a peace bond where one of the conditions of the peace bond was he made a public apology about what he did. So that's another option that is available. So those are some of the options. And I will also add that for any other criminal offense that might be found under the criminal code, if you can prove that that specific crime was motivated by hate or bias, then a judge has to take that into consideration for the sentencing. So somebody's sentence might be heavier, might get a longer sentence if you can prove that that offense was motivated by hate. So how do you actually start the criminal process? The quick answer to that is that you need to report what happened to the police. And before you do that, I think there are a few things to consider in order to decide whether a criminal option is actually right for you or someone that you know who's considering that. The first thing I will say is that there is a pretty high evidentiary threshold if in order to prove that a crime happened. So in order to prove that something happened and that it's a crime, you need to prove that something happened beyond a reasonable doubt. And that means that it's a pretty certain thing. A judge or jury has to be convinced that something happened, about 99.9% that, this is actually what happened in order to convict somebody. So that's one thing to consider. And the other thing to consider is that once you go to the police and they decide to move your case forward, and once the government prosecutor is brought in, you don't really have control or input over the process once that gets started. And that's because a survivor in a case like this is not a party. And you might know, if you've seen reference to criminal cases, they often have something like R versus the name of the person who's accused. And in that case, the R actually stands for the king, because we are a Commonwealth country, and then the name of the defendant who is accused of the crime. So that means that it's the government who's prosecuting the crime against the accused person, and the survivor is not a direct party to that. And that means the government lawyer who's assigned, the prosecutor is assigned to the case, doesn't represent the survivor. Of course, the survivor, will need to give evidence to build the case, but the survivor doesn't have an interest directly once a criminal proceeding starts. So that's another thing to consider. And the other thing to consider is just the history and the ongoing nature of the systemic racism, homophobia, and transphobia of the police. And that might impact how seriously or how not seriously they might take what happened to you, or what happened to someone that you know. And also, the last thing I will mention is that it's a pretty lengthy process. The justice system moves pretty slowly. It might take months, more realistically years, for a criminal trial to move forward. So that's the last thing I will mention in considering a criminal option. So I had a question here about, what people's thoughts were on the criminal process, the criminal code options. I think I'd be happy to kind of hear your thoughts, but I think we have sort of discussion scheduled for later in the session. So I'll share these sort of questions again at the end and discuss the civil process. So that's civil process is another option that exists outside of the criminal system, and civil litigation refers to any litigation that's not the criminal law. And unlike a criminal trial, the outcome of a civil trial is not a criminal conviction or jail time for the accused person or the accused person not being found guilty. But the point of a civil trial is to have the court say that someone who's bringing the suit was actually harmed by the other person, and that the person who brought the suit is entitled to some compensation, usually, for the harm that they experienced. And that compensation could be for money for counseling, for the time that they had to take off from their job because of whatever happened. So that's kind of, that's the point of a civil trial. And unlike a criminal case where the survivor is not a direct party, but the government is, in a civil case, a survivor would be a direct party to the case. And the other thing I'll mention is that to prove a civil litigation case in court, the evidentiary threshold is a bit lower. So you need to prove that something happened on a balance of probabilities as opposed to beyond a reasonable doubt. So that's something, that's less rigorous. So that's the civil process in a nutshell. And in terms of what kind of options might be available under the civil process, the unfortunate thing that I will mention is that there was a hate speech provision under the Canadian Human Rights Act under Section 13. So this was a hate speech provision where somebody could bring that, another person was, what they experienced or what they expressed constituted hate speech and they were harmed by it. And because it was under human rights legislation, the evidentiary threshold was lower. and the survivor who brought the complaint could actually be entitled to a compensation. It wasn't much. I think the cap is about $20,000, if I'm correct. But the kind of the outcome and the process was supposed to be a bit quicker and had a different purpose than a criminal hate speech. But this section was actually repealed by the government back in 2013 under Stephen Harper. So it no longer exists as a remedy, but it's something that organization like LEAF advocated for because we believe that a civil recourse like this is important to have to recognize the existence of a harm and something that is less difficult to engage in for a survivor than the criminal hate speech prosecution, for example. So it's something that we have advocated for in the past, and there was a bill in the previous government to bring this back, bring a version of Section 13 back, but it died in the process. So I think it's something that people discuss and bring up as something that we would like to see, and we hope to see again. The other thing I'll mention is that non-consensual distribution of intimate images is becoming a thing where a lot of different provinces are passing laws for people to have easily accessible remedies for that. That's not under the criminal code. So Ontario, unfortunately, doesn't have any laws on this, but there have been some court cases where the court recognized that sharing someone's intimate image without their consent amounts to civil wrong. So it is available. The remedy is available in Ontario as well, but provinces like Nova Scotia and New Brunswick have passed laws that make it a bit easier for survivors to apply to have the images taken down and also have some remedies available to them. The last thing I will mention is that the federal government has been announcing that they want to pass a bill to address online safety, one of which includes hate speech and other types of online harms. And it's been in the mandate letter for a while now, and they may be contemplating some of these civil remedies or ways to have the content taken down at least very quickly if it's something that's harmful. But we don't know what the details of this are yet because the bill has not been announced. It's just the intention of the bill has been announced for a while. So that's something that we're watching for. So considerations for pursuing a civil claim. If you are thinking of pursuing a civil claim, I think a couple of things I will just note here is that it takes even longer than the criminal process because a criminal trial engages someone's right to liberty and security because of a potential for incarceration. There are sort of time limits now imposed by the Supreme Court for a criminal process to finish, but that doesn't exist for civil trials. So it's an even longer process, and that means that the legal fees that someone needs to pay for a civil process to go through might be very expensive. So those are the two sort of criminal and civil arenas for online hate that I wanted to share with you. And I will also, I will conclude by sharing a couple of steps that you can consider when you are experiencing online hate, and if you think a legal option might be something that you want to pursue later on. And the first tip is to really collect evidence. And that might be very important to you because you want to keep a record of what's happening, and then you can present it to law enforcement, or you can also present it to the social media platform where the online hate is happening. So that's something concrete that I would advise anyone to do. And collecting evidence might look like taking screenshots, keeping a log of incidents and actions that happened, and also any actions that you took to try to report it, if it's applicable, different channels and what the responses were from those channels. And I think that if you know someone who's going through this, that's something concrete that you could do for that person experiencing online hate. Oftentimes it can be re-traumatizing and also overwhelming for a survivor to try to not only keep a log of what's happened to them, but also try to navigate what their options are. And oftentimes people might or law enforcement might ask if you actually reported what happened to the social media platform. And so you might want to have a response to that. And different social media platforms have different codes of conduct, which also makes it very difficult to navigate. So just sort of becoming familiar with what the complaints process is for different platforms, and also what it takes to file a police report, and just helping to organize that evidentiary piece might be a good supportive step. And so, yeah, that's the second point, is to become familiar with and use the complaints and reporting tool for the social media platform. And the other part is to seek out and form a support network. And this could be by, using some of the helplines that exist. There are a couple of online resources. I shared a couple of links to them at the end of this slide presentation. One is a US-based one, but it may be useful. And I think just trying to have this network, find other people that have experienced this, will be pretty validating to know that you're not alone in experiencing that. Have support for each other and share the information that might be helpful for one another.